Welcome all, and thank you for joining us for today's webinar. I'm Sara Anzani. I'm going to be taking you through the amended rules relating to the admissibility of asylum claims and third country removals, specifically the amendments to paragraphs 345A and 345 or 345D. Which took effect at the end of the transitional period at 11 p.m. on the 31st of December 2020. And these relate to non-EU applications for asylum made after that date. My colleague Alexis Slatter will then be looking at the guidance associated with these amended rules, and finally Jamil Dhanji will explore some practical points to consider moving forward with challenges to these decisions and notices. If you have any questions, please pop them into the Q&A box at the bottom of the screen, and we will deal with those questions at the end of today's webinar. So if we can turn then to the first slide, and starting with the Home Secretary's stated rationale for the amendments that we're talking about today. The explanatory memorandum of the Statement of Changes presented to Parliament on the 10th of December states at 6.3 that the changes to these rules on place of claim and inadmissibility are being laid as part of the ambition to overhaul our approach to asylum and illegal migration, delivering a firm but fair system. These measures will support our efforts to intensify the response to small boats and clandestine entry and lay groundwork for new legislation next year. So this webinar is obviously quite timely given yesterday's announcements from Priti Patel, and Jamil will be looking at that in some greater detail towards the end of the webinar today. So the explanatory memorandum, looking back at part 7.2 that you can see at the bottom there, it says that in broad terms the amended rules will apply from the 1st of January 2021, and they provide a means to treat as inadmissible to the UK asylum system the claim of someone who has travelled through or has connections to safe third countries, and that will include coming from EU member states. As currently drafted, they allow claims to be treated as inadmissible only if the asylum applicant is accepted for readmission by the third country through which they have travelled or have a connection. So at 7.4, it says that the changes aim to separate the readmission requirement from the admissibility decision, allowing the Home Office to treat applicants as inadmissible based solely on whether they have passed through one or more safe countries in order to come to the UK, they say as a matter of choice. They will allow the Home Office to pursue avenues for an individual's removal, not only to the particular third countries through which the person has travelled, but to any safe third country that may agree to receive them. So we turn then to the rules themselves, and starting with paragraph 345A. This states that an asylum application may be treated as inadmissible and not substantively considered by the Secretary of State if it's determined that, 1, the applicant has been recognised as a refugee in a safe third country and they can still avail themselves of that protection, or 2, the applicant otherwise enjoys sufficient protection in the safe third country, including benefiting from the principle of non-refoulement, or 3, the applicant could enjoy sufficient protection in a safe third country, including benefiting from the principle of non-refoulement because A, they've already made an application for protection to that country, or B, they could have made an application for protection to that country but did not do so, and there were no exceptional circumstances preventing such an application being made, or C, they have a connection to that country, but it would be reasonable for them to go there to obtain protection. So a few things to note here. Firstly, the exceptional circumstances that could prevent an asylum applicant from making a protection claim in a safe third country, as per paragraph 3b, are not defined. And neither is the connection that might be required to render it reasonable for an asylum applicant to go to a safe country to obtain protection pursuant to paragraph 3c. And of course, the ability now of the Secretary of State to know and determine whether an applicant has in fact made a claim for asylum in a European country is now more difficult, given that from the 1st of January 2021, she's not had access to the Eurodac database. In terms of what constitutes a safe third country, that's dealt with in paragraph 345b. And this states that a country is a safe third country for a particular applicant if, one, the applicant's life and liberty will not be threatened on account of race, religion, nationality, membership of a particular social group, or political opinion in that country. Two, the principle of non-refoulement will be respected in that country in accordance with the Refugee Convention. And three, the prohibition of removal in violation of the right to freedom from torture and cruel, inhumane or degrading treatment, as laid down in international law, is respected in that country. And finally, four, the possibility exists to request refugee status, and if found to be a refugee, to receive protection in accordance with the Refugee Convention in that country. So there is here a focus on individual circumstances and an acknowledgement that a country might be safe for some and not for others. What is concerning, however, is then when we move on to paragraph 345c at the bottom of the slide, which states that when an application is treated as inadmissible, the Secretary of State will attempt to remove the applicant to the safe third country in which they were previously present, or to which they have a connection, or to any other safe third country which may agree to their entry. So, of course, this only kicks in once a decision has been made to treat a claim as inadmissible. But once that decision has been made, what this provision effectively says is that the Secretary of State can remove an applicant to any safe third country which may agree to accept them, irrespective of whether the person has previously been present there, passed through there, or whether they have, in fact, any connection to the country in question. There are exceptions for the admission of inadmissible claims into the UK asylum process, and these are dealt with then in paragraph 345d. And what this states is that when an application has been treated as inadmissible and either removal to a safe third country within a reasonable period of time is unlikely, or upon consideration of a claimant's particular circumstances, the Secretary of State determines that removal to the safe third country is inappropriate, the Secretary of State will admit the applicant for consideration of the claim in the UK. As to what is meant by a reasonable period of time, or what constitutes that, that's not defined within the rules. But this is perhaps a good time for me to hand over to Alexis, who can take you through the guidance and any clarification on that particular point. Alexis. Alexis, you're on mute.
Sorry. Good afternoon, everyone. Hope everyone can hear me okay. So the first slide here is about the policy background to the new rules. The rules apply to all asylum applications made after the end of the transition period, and obviously don't apply to those entitled to reside in EU countries. So those rules applicable to those applicants 326E to F remain unchanged. In relation to the policy background, these rules are really a response to the lack of continuation into the Dublin system. During the Brexit negotiations, the UK government chose not to continue participation in that system as a third party or to incorporate its provisions into domestic law. And instead, they've come up with these new rules, really in response to the lack of access, like Sarah touched upon it, to the Eurodac fingerprint database, which was the EU-wide database operational since 2003, which really allowed the Dublin system to work, storing fingerprints, transmitting them, and cross-checking asylum applicants against that database. So it's really a response to that. The other plank of the Dublin regulation was obviously the family reunion provisions, they continue to apply to the end of transition period. There's a separate policy guidance document upon that. And the EU Withdrawal Act 2020, Section 3, there are statutory duties in relation to the family reunion provisions, but we don't have time in this talk to touch upon those. Perhaps that should be left for another day. But effectively, the government has laid a statement on the 8th of February 2001, has published a policy in relation to the legal route to family reunion, and will need to publicly consult upon the legal routes for unaccompanied asylum-seeking children in due course as part of its new plan. So the reason I think why the government decided not to negotiate in relation to continued participation in Dublin 3 is because whilst historically the number of people transferred out to EU member states under the Dublin regulation was high, since 2016, the UK has received more people than it has transferred to member states. And I think had some 2019 figures that there were 714 transfers to the UK, mostly from Greece, against 263 transfers to the EU, mostly to Germany and France. So that possibly explains the government's unwillingness to continue with the Dublin system. The next slide really, I think, as it gets to the crux of the mischief really behind these new rules, as Sarah's explained, that they, through the explanatory memorandum, they attempted to separate the admissibility decision from the readmission requirement. So the previous version of the rules immediately before these actually required, for example, in 345 capital C subparagraph 6, required that the applicant will be admitted to that country for safe third countries. Whilst we've seen from 345C that it doesn't contain such a requirement, what the policy does is to go further than that and say at page 14 that no inadmissibility decision must be made before return agreements are obtained. So I think that's potentially significant in terms of a challenge to the sort of policy adherence principle in Nadaraja and Lumba and Cambazi for the respondent to have to follow the policy guidance document rather than the rules, unless there's a good reason not to do so. There are a few other aspects where the policy, I think, goes further than the rules. Firstly, for unaccompanied asylum-seeking children who are specifically excluded under the policy. It's not quite clear why that isn't built into the rule itself, but page 7 of the policy guidance makes clear that these rules don't apply to children. And the last point on this slide, in terms of human rights claims as well, they don't fall to be treated as inadmissible. That's clear from page 6 and also on page 20, although it's quite clear from the guidance that human rights claims made either before or afterwards will fall to be considered on the certification aspects of the Asylum, Immigration, Treatment of Claimants, etc. Act 2004. So those old provisions in Schedule 3, the guidance makes clear will be used for human rights claims raised at any time. But the second point here about the long stop agreement is, I think, also significant. It's on page 15 of the guidance. And it says, whilst we've seen from Rule 345D, Roman numeral 1, this is the first exception where the asylum claim will be admitted for substantive consideration, is where removal to a safe third country within a reasonable time is unlikely. That's not defined in the rules, where it is in the guidance on page 15. That's given a 6-month date from the person claimed asylum. And although there are exceptions in terms of when the clock starts, possibly when it's paused, and whether it stops after an agreement is reached, which will most likely lead to claims brought in on sort of issues relating to delay, I think it is significant that the policy does include that long stop of 6 months where the rule doesn't. What is also noticeable on the next slide, please, about the neither the rules nor the policy guidance document include key definitions, and that's quite striking. We've seen for Rule 345A, Roman numeral 3, paragraph B, these phrases could have made an application for protection to that country and exceptional circumstances preventing such an application being made. Those just simply aren't defined at all in the rules and the guidance, which is surprising. And the next subparagraph C, in terms of the connectivity with the third country, they used in the previous version of the rules 345 capital D, there used to be a non-exhaustive list of factors, such as any time the applicant has spent in the third country, any relationship with persons in the third country, family lineage, regardless of whether the close family are present, and any cultural or ethnic connections. That rule is simply gone, and there's nothing in either the rules or the policy guidance which places it. But there is, as I say, that previous rule and the previous version of the policy, which perhaps will continue to have some relevance in relation to those issues. And just lastly, in terms of challenging the decisions, there's a useful document, another policy guidance, asylum screening and routing guidance, which contains information which isn't included in the actual screening questionnaire itself, which in the third column there, which is useful to prepare clients for the questions that they're likely to be asked. And as a result of the lack of access to the Eurodac system, it's clear both from that guidance document and also the inadmissibility policy document at page 8 that the screening interview is going to be the primary interview at which evidence is going to be obtained for third country inadmissibility decisions. So that's going to be based on voluntary disclosure, and will also carry with it possible Section 8 warning, credibility warnings under the 2004 Act. So there'll be an internal referral to the third country unit from the National Asylum Allocation Unit, which will summarize reasons and evidence. The policy guidance pages 8 and 9 make clear that that's not a decision and isn't subject to the normal rules of evidence. But what's more questionable, I think, is that the same the same point is made in relation to the notices of intent which will be issued. These are dealt with at page 13 of the guidance. And what it says is that neither this consideration nor the notice of intent constitute a formal decision. It's simply an information letter to the claimant to inform them how their claim is currently being managed. And it's striking, there's a template of the letter that the individuals will be issued with, and it doesn't purport to give an opportunity to make representations or even give any indication of the evidence that's been held against. So it just simply says we're still reviewing the evidence available to us as part of the consideration. We may make inquiries with safe countries to verify evidence or to ask if in principle they will admit you, but it doesn't seem that there's any opportunity given by the respondent to allow representations to be made. So that raises arguably issues of procedural fairness in relation to the decision-making process. The actual decision itself is dealt with on page 18 of the guidance, and that's going to be simply a question of whether on the balance of probabilities the rules 345A has an association with, or B, a safe third country are met. And if it's considered that they are met, then respondent will also then give consideration to certifying the case under Schedule 3, either Part 2 if it's a listed country, or under Part 5. So the similar provisions for the human rights. And in relation to the last point about the fresh claims, they won't apply to these decisions only after, possibly in accordance with ZT Kosovo, although that was a Section 94 case, but they'll only, that 353 will only apply after the certification process. Judicial reviews likely to have suspensive effect, and will also, particularly where human rights issues are engaged, will likely to require determination of disputed issues of fact as well. So that's all I'd like to say. I'll pass you on to Jamil. Thank you.
Thanks, Alexis. Well, in the time allotted to me, I want to step back for a moment and just give some thought to what these changes are likely to mean in practice. And I thought it might be helpful to just begin by visualizing how the Home Office sees this procedure operating in practice. This flowchart is from the new Plan for Immigration Policy Statement that was published yesterday. And you'll be able to see, as Sara and Alexis have pointed out, the splitting of the inadmissibility part of the process and then the readmission part. So the first question that would be asked would be whether or not the person is in fact inadmissible to the asylum system. Once that decision has been made, there will then be the practical question of whether the person could actually be removed. And you'll see that on the very right here, and I'm going to come on to this at the end of my part of the presentation, we have this idea of only granting temporary protection status, which I'm sure you would have read about yesterday, and is a very, very worrying potential development. But this, I hope, gives you just a visual of how the Home Office foresees the system in practice. As I said, what I want to do is trying to just think of a number of the points that come out of the new rules and the guidance and how it might actually work. But before I do, it's worth thinking about what the point of these changes were. Why have they been brought in? You may have read from the policy statement yesterday that all of this is about making the immigration system fairer or making it more efficient. I think we all would agree that that's actually not what this is about. We've left the Dublin Convention. We need to fill that gap. It's about making the hostile environment more hostile, creating this idea of a disincentive. And it's about sounding tough on immigration so that the public thinks that the government's actually doing something about what sometimes is perceived as being a problem with immigration in this country. But what it's actually going to lead to, and I think you would all probably agree with me, is a longer and less efficient process, probably a more expensive process as we strike deals with other countries to try and, for example, the idea of having this safe other third country. It's going to lead to lots of extra litigation as a number of these concepts and terms that are not defined in the rules and in the guidance are interpreted by the courts. And I think most importantly, from our point of view, it's going to lead to untold suffering for people that have already been through a lot, having fled their home country, made a very difficult journey at times to get here, and then placing them in a position where there'll be extra delays. And when, if they in fact get status, the status may be uncertain. Again, just flagging up what I'm going to come to at the end, talking about the new policy statement. One of the questions that's been touched upon by Alexis and is covered in the guidance, but I think it's worth dwelling on for a moment, is how the Home Office will actually know if someone has travelled through a safe third country. As Sarah and Alexis have already said, the government will no longer has at present access to the Eurodac database. So immigration officers will be left with essentially trying to work out whether somebody's been through a safe third country based on what they say and any documents that they might have on their person. And the guidance goes into this in quite a lot of detail. So the clearest example will be when somebody discloses an interview. I was in France, I was in Belgium for a few weeks trying to find an agent. Well, based upon that verbal testimony, the immigration officer might be able to conclude on the balance of probabilities that the individual's been through a safe third country. On another end of the spectrum, this is covered in an example in the guidance, a passerby might observe somebody coming in on a boat and disembarking, having travelled in an easterly direction. That's the example that's given in the guidance. That's not going to be sufficient, according to the guidance, to prove that the person has come through a safe third country. And then a middle example, one where it could be proved or it might not be proved. Somebody's found with receipts on their person showing that they've been in France, or showing French receipts essentially, and trying to connect those receipts to the person who had them in their possession to try and show that the person's been through a safe third country. So that's going to be the first challenge, I think, for decision makers, is actually being able to prove on the balance of probabilities that the person has been through a safe third country. Then obviously there are a number of difficulties with the rules themselves, as Sarah and Alexis have already touched upon. Undefined terms like what exceptional circumstances preventing an application for protection being made actually are. The guidance gives the example of somebody being under the coercive control of another person, so somebody essentially being trafficked. That example, I imagine, is going to come up in many, many cases. And I think one of the tasks for decision makers will then be to try and distinguish between those who are actually under coercive control and those who are traveling by choice. And that distinction is going to be a very difficult distinction to make. I think it's quite a dangerous road to go down. And then, of course, we'll have to actually look at issues that arise in the third country itself. So issues to do with onward refoulement and things like lack of connection, things that have already been covered by Sarah. But one of the last points to make on this slide, of course, is that we don't actually have any returns agreements with any safe third countries. So even if an individual is found to be inadmissible to the asylum system, because they're probably not going to be removable to a safe third country because there is no such removal agreement, they will end up filtering in to the asylum system here, having had in all probability a long delay while they wait for that process to take effect. But I'll come on to that in a moment. Again, Alexis has touched upon this, but there is this idea of a 6-month long stop. In fact, what 345D1 refers to is removal needing to be possible within a reasonable timescale. Now that time starts from the point of disclosure of the person's presence in the third country. So although it would be seen to start from the point when the asylum claim is made, if at a later date the person discloses that they have been in France, say, according to the guidance, the time would start from the point of disclosure. it's not 6 months, it is a reasonable timescale for removal, but there is this idea of a 6-month long stop. That long stop and the reasonable timescales essentially until the third country accepts the person's return or readmission or removal. So it's not until the person is actually removed. So we could have a situation where the third country agrees at the last moment in the 6 months to accept the person's readmission. It's then after that that there is an undefined period of time when the person could be detained until they're removed. What the guidance refers to is there being no rigid timescales, but that removal after acceptance by the third country must take place within a reasonable time. So again, this could be a far longer process than just a 6-month long stop. And although there's this idea of a 6-month long stop and the rules refer to a reasonable timescale, I think what we know in practice is going to happen is it's going to routinely be the case that we're looking at 6 months for pretty much every person that finds themselves in this situation. There's also in the guidance the fact that if someone is referred to the NRM, so claiming that they've been the victim of modern slavery, the reasonable timescale for removal doesn't actually begin until that process is completed. So they're being brought into the inadmissibility process is essentially paused until the NRM process completes. So they're almost being hit with a double whammy of having to wait, first of all, for the NRM process to conclude, and then possibly at the end of that for this inadmissibility process to conclude. And then, as Alexis has already pointed to, there are a number of distinctions that are made between the rules and the guidance. The rules don't cover everything of materiality that's in the guidance, and that's worth knowing. And then moving on, so the guidance also refers to what happens to asylum claims that were made before the rules were changed on the 31st of December of last year. What the guidance says is that, so first of all, that these new rules can be applied to individuals who claimed asylum before the 31st of December, but such a decision is unlikely to be appropriate if the individual would have been unlikely to receive a similar decision under the previous rules, or their process through the asylum system has been substantially delayed in comparison with average timescales. So I think in practice, we're not going to see many asylum claims made before the 31st of December who find themselves affected by these new rules, but it's possible. So we need to be alive to that. And Alexis has also touched upon some of the possible challenges. Essentially, I think what we're going to be seeing is quite a few judicial reviews of decisions on inadmissibility and on certification. Delay challenges, because of course, as I've already said, when we think about what the rules say, it's decisions within a reasonable timescale. And if there's no reasonable prospect that somebody is going to be removed to a third country, it's not the case that one should necessarily wait for the 6 months to elapse. It will be fact specific. And then also, of course, in due course, I'm sure that we'll end up looking at possible systemic challenges to the whole system. And it's obviously too early to comment on the likely merits of such a challenge. Finally, when it comes to just dwelling on what we've covered with the new rules and the new guidance, it's worth noting that other countries have adopted and are adopting similar measures. So last November, Ireland adopted almost identical measures on inadmissibility. And I think what we might end up seeing is something of an arms race in countries putting in place these very strict restrictions on the application of the Refugee Convention, essentially foisting asylum seekers from one country to another. And it will be very interesting to watch how it develops on an international scale and the extent to which the spirit of the convention is actually being respected. Finally, I think it would have been remiss of me to finish today's webinar without talking about the policy statement that was published yesterday. There's a lot in that policy statement. I clearly can't cover everything. I'm sure in due course there'll be a webinar that covers the policy statement, and once the consultation is finished and there is draft legislation to talk about, I'm sure there'll be webinars on that too. These points here were the ones that jumped out at me as being related to what we're covering today and related to the asylum system more generally. So just running through them, the government talks about its ambition to pursue returns agreements and arrangements with international partners as part of future migration partnerships. And I would just flag the last bullet point there as well, because the two I think are probably likely to be related, although the last one just talks about removal more generally. I think the government's approach is going to be, as it approaches trade agreements with other countries, it's going to be including immigration as being something that's on the table. And we can see that in the final bullet point, where talk is used of the threat to actually control visa availability to countries if they don't cooperate with receiving their own nationals if they're being removed. So I think we're going to see this as part of, the UK's negotiations with other countries now that it's out of the EU. There's mention of keeping the option open to develop the capacity for offshore asylum processing. So of course, this is the Australian model, what's been trailed in the newspapers over the last few weeks, trying to find some other safe third country where asylum seekers whose claims are inadmissible could be sent to. And Sarah's covered how the rules allow for that. The introduction of new asylum reception centres. So essentially, instead of housing people in hotels, they're going to be housed in these new asylum reception centres with a view to, I imagine, the government will say, save money, but also making things more speedy. Again, I ask one question, which is, to what extent is this going to be different to a detention centre? How free will people be to come and go? What will the rules be? So that's a worrying proposed development that I'm sure will be challenged in due course. The fast track appeals process has raised its head again, but again, the questions that plagued the DFT are likely to still exist. How on earth are they going to make sure that a fast track appeals process is procedurally fair? The government's failed to get that right in the past, so that's going to be something that we have to watch closely. And then I suppose the most worrying development, in my view, this idea of temporary protection status. So for individuals who come to the UK, it says they're indirectly, but I imagine in ways that the government doesn't think was the right way to come to the UK to claim asylum. For people that claimed too late, so who don't claim immediately. And there are other factors, I'm sure there'll be similar factors to the Section 8 factors, would receive a temporary period of leave, no longer than 30 months, and there would be constant reassessment of the risk to them returning to their country of origin or to another safe country. And just reflecting on the purpose of these new rules, it seems incredibly cruel to place people that have come here and who have been found to meet the definition in the Refugee Convention for protection, to place them in this perpetual state of limbo. And I think it's very arguable that this doesn't meet some of the requirements of the Refugee Convention. And I can imagine that there will be legal challenges to this aspect of the policy statement if it becomes law as well. Then in terms of the actual consideration of claims, there is a proposal to raise the standard of proof for assessing credibility in asylum claims. So they've split it into credibility and risk, and talk of considering credibility on the balance of probabilities and then risk on the lower standard. There's talk of new measures for assessing age, and quite worryingly, a return to the use of, a return to the terminology of the use of up-to-date scientific methods, which sounds ominous. And then finally, talk about restricting family reunion for those that are given temporary protection. So all in all, new rules, and once I imagine this policy statement's converted into law, potential new legislation, but it's the same challenge, and we need to make sure that we are able to rise to that challenge. That's all that I wanted to cover, so I'm going to hand back to Sarah to see whether there are any questions that we can answer.
Thank you, Jamil. I don't think we actually have any questions in the Q&A box. Oh, hang on, there is in the chat. So this from Katie Nelson. She says, thank you for the webinar. I have a question about timeframes for removal after readmission is accepted by third country. As you said, the Home Office must remove the person within a reasonable time frame, but they are not subject to the long stop or quote, other rigid timescales. Appreciate this is undefined, but are there, but are there any options on what a reasonable time frame for removal may mean in practice? Jamil, are you
Yeah.
deal with that?
So I think once we get to a point where a country has agreed to accept the individual's return, it's really going to be about what's holding up that removal, the steps that are being taken by the government to actually remove the person. So if it's a case where I imagine the government says France will take the person back and then nothing is done within a month or two to actually progress that removal at all, I would be saying that we can talk about challenges, because it shouldn't be too difficult to affect that kind of removal, but it would be case specific. And I think the key thing will be, what's the government actually doing to try and move the removal along. Reasonable, as you know, is used to cover all manner of sins, but I would say that it will be fact specific, and if the government's not trying to move things along, then we could have a challenge.
Well, you have our contact details there on the screen at the moment. If anybody does have any other questions that you perhaps want to ask us directly, then please do reach out. I am particularly interested, I'm sure all of our panellists today are interested to hear from any experiences that any of you have from the front line as these new provisions roll into place. So please do keep in touch. And yes, unless anybody has anything else that they want to add, I think we can end there.